Good evening, buddies. How are you doing? Hi. How are you? Hope you had your coffee and all those things. Are you ready for the class? Shall we begin? Okay. So, guys, I had sent you the notes, if you remember, on my group. That is the CA Interlaw Amendments. And, we had also sent you the charts, Indian Contract Act wala charts, and also the questions part. Yeah, I still have to send. But there was one more called the highlights, correct? That also I had sent you, the highlights of the Companies Act. So today we have to do the amendments. Very, very good evening, all of you. So today we have to do the amendments part of it and understand what are the amendments that have come. So this particular file, which is called as highlights, okay? So always remember, friends, when there is an exam, right? Now, for example, November 2020 exam is there. So you will see all the amendments that have come till, around April. That is what you will check, correct? All the amendments. But this time, not only this, since the May 20 attempt was cancelled, so all the amendments till October 2019 also would definitely come in this exam. So October 2019, predominantly October 2019 to April 2020. This part also will come. And from April 2019 to October 2019, this also will come. 6 months amendment. Not just that, but we always concentrate on the new amendments, but we will forget about the old amendments. In 2018, from May 2018 to April 2019 also many amendments came. That also examination they'll ask. You remember always that just because amendments came here, all cannot be asked. Previous whatever was there, that also they can ask. So we need to be a little smart in the way we are studying. Okay. So all the amendments for November 2020, I mean the new amendments, relatively new amendments, have been given in this file. Which file? Which is named as CA Interlaw Revision. This file. Okay. So if you see here, I have given you in this particular thing, page number, if you see 5, page number 5. Yeah, important amendments applicable for November 2020 exam. So in this, all the amendments which are relatively new, which has obviously not been asked in the exam, which was supposed to come in May and supposed to come in November, that is given. What about this? Whatever came from May 18 and April 19, that also is given below, correct? That also is given below. Here below it is given. Plus, we also need to see the overall amendments that have been coming since 2018. For that, I have given another file, and that is the highlights file. Correct? The highlights. This is available on my Telegram group. I've already told you on day 1. You can go to my Telegram group. I've already uploaded. One thing I still have to do it is the questions part. This part I need to upload. We will see that later. No problem. So guys, this amendment. So if you see amendments as per the Companies Act 2017. In Companies Act 2017, now many amendments came, which became applicable over a course of time. Just because it came in 2017 did not mean that everything came in 2017 only. Over a period of time it came. So what period of time? See here. This is just for your information I have given. Page number 345, 2, 3, 4, 5. If you see, these were all the Company Amendment Act, changes. And if you see the dates, it came in 2019, July 2019, August 2018, July 18, sorry, like that. So what I am trying to tell is, from May 18 to April 19 also, there were many changes that came. Correct? May 18 to April 19 also, many changes that came. That part also we need to study. Where is that part? That part is given in this file. The highlights file. Highlights file speaks about amendments as per Companies Amendment Act 2017. Amendments as per Companies Amendment Act 2017. Okay. So 2018 and all those things. So guys, I would request you to attend the classes regularly again. You will not be able to go back to the old videos and see later and all those things, because this is to enforce discipline. In face-to-face classes, you guys will come and sit in front of me and you will listen, you will have no choice. But now what happens is, since you're at home, you'll aram se watch 10 minutes, then you'll go out, then you'll see, let me see later and all those things you will think. So as I told you yesterday only, will I be putting up the thing on YouTube? Maybe later, sometime in October. That may be too late for you guys. Why I am putting it in October is, you also need to put in some hard work and you should have logged in and all those things on time. And October, the ones who want to revise can revise later. But we are, we are doing like 20-25 days before only now, right? So time is money and time plays a major role. So the logic is very simple. When I am here spending time, you also need to take out 2 hours a day and come. So later I will watch it. I have anyway got the link, all those things. Now you can click the day 1 and day 2 video, you will not get the access, because our team has removed it. So what I am trying to tell is, because this is only to enforce discipline. When we put in efforts for you to, press the link and then add all your details and all that, it would be unfair on my part to make the videos public. Then you'll be like, why the hell did you take all the details? That's valid. When you have put efforts to put all the details, it is my duty to send the links to everyone. Links have been sent for all the classes to everybody already, right? So if there's any change, we will let you know. So you guys have to come on time. Whenever you come, it's okay. You come at 6:10, 6:15, whatever, but come to class is what I'm saying. It is just like a face-to-face class only. Only thing is, you're sitting in your respective homes. So what I am trying to tell is, do not be lax, push it and attend the classes. Later, can I watch the classes later? As I told you, the links will not be available. Sir, but how to revise? As I told you, sometime in October, I will make the videos public. But for you guys, you have already shared all your mail ID and all those, you have put the efforts. It would be unfair on my part to give access to everybody. It should only be given to you. When I launched this also, I clearly told I only need few students, it's okay, but interested students, okay? Sincere students, that's the only thing, okay? Yes. So the classes will be around 16 to 20 hours, depends. Later I'll also put up a couple of videos as well, that's the thing. So, let us begin. Let us see the amendments now, okay? So amendment number 1, let's go through. Yes, these are which amendments? These are the amendments that came, post October 19. Post October 19. That's the thing. Before amendments also is covered in this sheet only, and the 2017 wala amendments, all these amendments, see, it's just the date is given, with effect from date is given here. In page number 2345, a notified date is given. But the notified date is something that obviously now everything is applicable. So these amendments are given in this sheet, okay? Is that system clear? That's the thing. All amendments giving at one place, it's stupid, because we need to see what came when, timeline. A slightly older amendments are here and the newer amendments are here, that's all. There are 2 files, very, very simple. Older amendments are in the highlight sheet, newer amendments are right here. Both have been shared already. Is that clear, guys? So you need to know where things are in the material. So let us begin. So first of all, talking about names of the company. So if you see in the memorandum of association, as I told you, along with the amendments, I'll also be doing the chapters. I'll not be going chapter wise, that I don't follow that anyway. If you see, these are the chapters that we have, guys. Preliminary, incorporation, prospectus, share capital, correct? Acceptance of deposits, registration, management, administration, declaration of and payment of dividend, and of course we have 2 others, 9 and 10. So 9 and 10, 9 would be accounts and 10 would be auditors. Correct? Yes. Notified date of provision, etc. should be mentioned in the class. No need at all. Absolutely no need. All those things, do not waste your time. No one will ask any of those questions. Okay? Yes. So if you think about it, preliminary we have already finished. See, we have seen all the types of companies and all. Yesterday we saw. And the concept of corporate whale, where each company has these directors and in front of the directors there is a whale. Whenever need be, the company I mean, the courts can lift the corporate veil. The corporate veil concept has now been shifted to CA Foundation. Though you know the concept, it has been shifted to CA Foundation. So CA Foundation people have corporate veil, and there are three doctrines, if you remember: doctrine of ultra vires, doctrine of constructive notice, and doctrine of indoor management. There are three doctrines that we need to remember. Okay. So now coming to these amendments, guys. Yes, first amendment is talking about the name clause. Now, when I'm talking about the name clause, I also need to understand what is the AOA and the MOA. So the AOA and MOA both together are called as the charter of the company, whereas MOA talks about the external charter of the company. Together it's called as the constitution, whereas AOA talks about the internal regulations, as we know. And if you see in the MOA, the various types of clauses are there. Easy to remember. You write your name, and your sole objective is to become a CA. Ignore that E. You're writing your name, and your sole objective is to do what? Become a chartered accountant. Very, very simple. So S is your situation clause, O is your objects clause, L is my liability clause, E clause and all is not there. So this clause is not, it's just silent. C is what? Capital clause, and A is association clause. One by one it's there. So these are various clauses which are there in our MOA. So the name clause, can I name whatever I feel like naming is the question. So if there is a company called Infosys, can I open a company called Infosys? Correct? If there is a company called Wipro, can I open one more company called Wipro? So these are the things that are there in the law that this cannot be done. So there are certain rules and regulations which were there. That rules and regulations have been amended with respect to the name clause. What you can do, what you cannot do, certain clauses have changed. So that is amendment number 1, buddies. Rule number 8 of Companies Incorporation Rules. Correct? Rule number 8 of Companies Incorporation Rules. So here, should I write the rule number and all, sir? No need. I repeat, no need. It's absolutely fine. So guys, these are the new rules that have come, which speak, they have given certain illustrations also to understand what is allowed, what is not allowed. So for example, here they are trying to tell green technology is the same as Green's technology. So they will not allow you to list that name. That will not be allowed. Next, Pratap technology is same as Pratap's technology. So singular, plural and all you cannot play around. Wipro, I cannot name it Wipros and all those things. Okay. Third one, SM computer, BERT. SM computer is an abbreviation, but SMS computer will be totally different abbreviation. So is that allowed? Yes. So in this, the third example will be allowed. So these are the new rules and regulations that they have come out with. So green technology, Green's technology, like that if you put, they will not allow. Pratap technology is already there, you make it Pratap's technology, they will not allow. SM computer on the other hand, you make it SMS computer, that they will allow because it is an abbreviation. So SM computer may be different, SMS computer may be different, that's okay. Then you cannot add dots, full stops and all those things and say it's a different company, because ABC Limited is the same as A dot B dot C or A space B space C. It will remain the same. Teamwork Limited is the same as Team at Work Limited and Team hyphen Work Limited. Correct? That's the thing. New Pratap Limited also can be done, but then it depends on the, what is the thing. If it's the same line of business, then they'll not allow. If it is a different line of business, they may allow. So that also, adding new, old, all these things, generally they will disagree. Next, use of different tenses also. Ascend solutions, ascended solutions, ascending solutions. Pawan I'll have, thanks Da. Ascended solutions, ascending solutions, all these things are different. I mean, what I'm trying to tell is you can't do past tense, present tense and all that and name the same company. They'll not be allowed. Similarly, speak English is the same as spoken English, or even for example, speaking English. So all these things you cannot do. Then use of different phonetic. Phonetic means what? The sound, similar sounding. Phonetic means sound. Similar sounding. One second. Thank you. So phonetics means what, guys? Similar sounding. So as I told you, Infosys, SYS and Infosys, SIS sound the same. So you can tend to get the, you tend to get confused. SMS Pharma and SMS Computers, yes, that is possible. SMS Pharma, SMS Computers, both are different. It is possible. So that if you have those words there of your business, then they will allow, no problem. So Chemtech Limited is the same as Chemtech Limited, because if you see, Advait Learning Private Limited is the name of our company. There is one more Advait Solutions or something, Advait Solutions Private Limited. So they are allowed. That is into consultancy. We are into teaching. So that is allowed. These amendments aren't in depth in RTP. RTP and all you ignore, guys. In RTP, sometimes they'll give, sometimes they'll not give. You stick to this, it's enough. RTP, some they'll give whatever they feel like. And in RTP, they will not give it in a structured manner. RTP, they'll just dump everything, clause number and all they'll put there. So you need to sit and search. You just stick to this, it's fine. So BK Limited is the same as BK Limited if you listen to it. That is called phonetics, right? Or BKY, B space KY, B space K, all this will remain the same if the phonetically it remains the same, okay. Then Ultra Solutions is the same as ultrasolutions.com. So just by adding .com etc, nothing will change. However, Supreme Ultra Solutions is not the same as Ultra Solutions, obviously. So ultrasolutions.com is different, Supreme Ultra will be totally different. The order of words in the names also you cannot play around. Like Ravi Builders and Contractors is there. You will open one more company, Ravi Contractors and Builders, or Ravi Shankar. That all those things you can not do. But Ravi is a different name. Ravi Shankar is a different name. So can I say Ravi Shankar Builders and Contractors? Yes, that is possible. So Ravi Builders and Contractors is one. Ravi Contractors Builders is one, and Ravi Builders and Contractors Limited, they are all the same. Ravi Shankar if you add, however, that will be different, okay. So these are all the illustrations given by MCA only. So this they were never asked in the exam, because these are the changes that have come. So they can ask you in MCQ or a couple of marks or 3-4 marks somewhere, they can ask. So all these things, that's why we are doing. Now congenial, use or definite or indefinite article like the, all these things. So but if it's a space, for example, congenial tours is same as a congenial tours. Isha Industries Limited definitely is not the same as Anisha. Just because you added, you change the name now. It is not Isha, correct? It is Anisha. That's the thing. So if you see, these are all the various things. Karthik Agarwal, BSR has opened many firms. Buddy, I am talking about companies. You are talking about firms. Firms you can open whatever you want. Do you think partnership firms are not regulated by anybody? Correct? So you can, unless it is registered. So there are so many unregistered, restaurants also. Shanti Sagar, new Shanti Sagar, brand new Shanti Sagar, all those things. So firms and sole proprietorship, nobody will give a damn. I am talking about companies here. Company you need to register under the Companies Act. So there you cannot play around with all these things. Got it? Next, slight variation in the spelling and two names including a grammatical variation. Color and color. This is UK English, one is US English. So COLOR, COLOUR, that cannot be done. Disk Limited, Disk Solutions and Disk Solutions. So C and K, again UK and US English. Cannot play around with all these things and do it. But it is not the same as Disco, because Disco gives a different meaning altogether, okay. So that's the thing. Mind you, these things are always about companies. It has got nothing to do with sole proprietorship. It has got nothing to do with partnership firms. They are different. It has got, right? So here in companies only, I'm talking about all these things. Complete translation or transliteration and not part thereof, Hindi, English, that also. So I cannot completely convert it into another language and have the same company. So National Electricity Corporation, correct, is same as Rashtriya Vidyut Nigam Limited. National Electricity Corporation is the same as Rashtriya Vidyut Nigam Limited. So if you see, Hike Construction is not the same as Hike Nirman. That's the thing, because you have just, changed one word. That's a different thing. Whereas here, you have completely changed everything. Rashtriya Vidyut Nigam Limited. Correct? So these are the things. So addition of the name, etc. of a place exists which does not contain the name of any place. Illustration. So if you see Salvage Technologies is an existing name, it is the same as Salvage Technologies Delhi. You cannot add one name of the place and make it a different company. That is not possible. But Retro Pharma Ranchi is not the same as Retro Pharmaceuticals Chennai, because here a name is already there. A place is already there. You are adding some other place. So that is possible. Yes. Name which has an excellent goodwill is being impersonated by partnership firm, it is allowed. That doesn't come under Companies Act, that comes under your intellectual property. So if you already have an intellectual property on the name and somebody else is cheating you on that, you can definitely go there and fight, because you have an intellectual property already. Then addition, deletion or modification and adding of numerals, etc. not allowed. So if you see Thunder Services is the same as Thunder 11 Services, One Thunder Services. Style Garments 11 is the same as Style Garments or Style 12 Garments, Style 11 Garments, all that. You can't change the number and start one more company. So if you see Virat Kohli has 1-8, so you can't make it 1-8 company, like all these things. Infosys Computer and Infosys Tours and Travels, again it is possible, but Infosys has already taken a brand name trademark on the word Infosys. So like Virat Kohli would have taken a trademark on this particular thing, and all the other connotations which are allowed. You would also have taken trademark on the color used as well. So tomorrow if anybody uses that, he can say, boss, you are using it, it is wrong. Got it? But there are certain common names like Ganesh, Ganesha, then Shiva, Shiv. Now these things nobody can take a trademark. Nobody can take a trademark on these words, because these words are very, very generic. Generic words nobody can take a trademark. Only if you come out with a unique name, then definitely you can take out a take the trademark on that. So this 1-8 of Virat Kohli, his clothing brand, etc., he can definitely take a trademark on the styling. So you can take the trademark on the wordings, you can take the trademark on the entire word and styling, you can take the trademark on the font. If you see all these big four, they take the trademark on the font of their presentations also. Nobody else can copy the font. They have created a font, by the way, and they have taken a trademark on that, intellectual property on that font. Nobody can, steal the font. Nobody can use the font. It can only be done by the particular big four, that is your KPMG, EY and all those companies, right? Existing place of name means, I didn't get what your question is. Yes, so that is the thing. There are certain undesirable names where you cannot use the Trademarks Act, you cannot use the Emblems Act and all those things. You cannot use, the names of popular personalities. I cannot say Virat Kohli CA Academy, Narendra Modi CA Academy, Rahul Gandhi Nursery, correct? All that I cannot use, all right? So those people who are already there cannot. And I cannot use the word British India and all these things. This you can go through, it's nothing great. And of course, any identical name with a LLP also, somebody asked that question. Yes, that also cannot be used, because of course LLP and Companies Act both are governed by MCA, so it cannot be done. And if I use any identical name which is company which is already dissolved before, can I use that? Yes. So if you see 2 years after that company is already finished, only then, 2 years after liquidation, only then I can do. I cannot use any national hero's name as well, correct? Not possible. I cannot use the word stock exchange, venture capital, asset management, insurance, unless actually it's an insurance company and I have taken the requisite approval, unless it is a venture capital fund, and unless it's a asset management fund and I have taken the approval of the necessary people concerned. Otherwise, it cannot be done. Just because you want to do it, you cannot do it. I cannot use the word IRDA and all those things, right? And I cannot use the state whenever I feel like doing. I cannot say Haryana Limited, Mysore Limited, Bangalore Limited, like that. I can say Royal Challengers Bangalore Limited, that is possible, correct? I cannot say Bangalore Limited, that is wrong. Then The name Silk Manufacturers Private Limited, manufacturer's skill are descriptive names as they merely describe an activity, and the order is not relevant while determining a descriptive name because you're just describing what you're doing. You know, silk manufacturers or manufacturers of silk. It's the same. So that doesn't matter. What really matters is what you have named. So that is the same. Technical Vista Limited or Vista Technical Limited, they are not descriptive because it doesn't describe what. Vista Technical means what? What are you doing? Technical service, you can define so many things, right? So then again, it cannot be taken into account like that. Foreign countries and all I cannot say. Bulgaria Limited, Rome Limited, Italy Limited and all that I cannot tell, okay? That is the scene. So the applicant, the proposed name of a Nidhi company also is the same thing. Nidhi company, Section 8 company, all these things you cannot copy from the normal Companies Act, whatever you have. If you are a Section 8 company which is there for philanthropic purpose, so you cannot copy a name which is already there, is what they are trying to tell. Proposed name, if it has been released from the register of companies upon change of name, that also, like for example, two companies amalgamate, correct? For example, Hindustan Unilever Limited amalgamated with GSK, GlaxoSmithKline. They amalgamated. They started a new company, let's say. Now, let's say it was actually called GSK Consumer Foods. Now, when they amalgamated, they came with a new name, assume. They came out with a new name. They came out with HUGSK or something like that. They didn't, but I'm just saying. If they came out with a new name, can I use the old name, GSK Consumer Foods Limited? Yes, after it is released, correct? If you see, 3 years should have not elapsed. So if you see, if the old name is obviously gone now, I have to wait for 3 years. If the old name, if the old company is closed now, I have to wait for 2 years before I can use the name. These are the new rules, okay? That's the thing. Then of course I cannot use all these things, guys. Republic, President, Republic TV, it is just a brand, but the company name will be completely different, okay? Rashtrapati, small scale industries, Khadi industries, minister and all I cannot use. Federal, municipal, panchayat, development authority, prime minister, chief minister, forest corporation. These are the things that I cannot be using in my name. So this is the amendment number 1. Did we understand? Very, very simple name. In depth we have understood. Yeah. So thank you, Banu. Yes, I will have my water. Thank you so much. Did you get that, guys? Amendment number 1 done. As I already explained, there are 2 sets of amendments. One set of amendment is the newer version, 6 to 8 months old. The old and slightly older than that is also there in that sheet, I'll tell you. But the old amendments which came in 2017, which actually were applicable from 2018. Last 2 years amendment, you need what we are doing. So one sheet has the newer amendments, the other one has older amendments. So in that way, we can take that into account. Yes, got it? Yeah, there was a brief problem in the internet. Now it is solved. All right. So let us go into the second amendment, guys. Amendment number 2. Relaxation of active non-compliant company. Relaxation of active non-compliant company. Are you able to see, guys? Let me just restart the internet and come. Hold on. Be here only. I'll come. I'll just restart. It's showing poor connection here. I just need to plug out and plug in. Hold on. All right, guys. I had a small internet connection problem. Now it's sorted. Are you able to hear me? Hello, mic testing 1 2 3. Are you able to hear me? Yeah, can you see me properly? On my side, there was an internet issue. Now it's fine. What? Why? What did you do now? It's clear? Okay. All right, guys. Cool. Let's begin. Let's continue. Okay, so now we are talking about amendment number 2. This speaks about relaxation to active non-compliant company. So what do you mean by this active non-compliant? Let's discuss. What do you mean by active non-compliant? What is this active? So bit of history is needed to understand rather than blindly studying the amendment. Let's see. So what happened was, correct, in when what happened in 2016 at the beginning of 2016, they came out with an income disclosure scheme. Remember? Income disclosure scheme. So income disclosure scheme, they said, you please come disclose all your wealth, correct? And what will you do then when you disclose all your wealth? You will come and take 55%, give me 45% tax. Cool, no questions asked. You have not been filing your returns properly. You have lot of hidden income. Please give it. In India, when somebody comes and asks like that, still people will not go forward and give. Government is telling we will not do anything. Like I remember there was one Vada Pav fellow. Vada Pav fellow was selling it for, I mean, his Vada Pav obviously for 20-30 rupees, and he deposited almost around 120 crore hidden income. Correct? Vada Pav guy. So the tax department is asking, what are you doing, sir? Vada Pav. How much income undisclosed? 120 crore. 120 crore. How did you get? The government is about to ask. Vada Pav fellow says, hey, cheating, cheating. What did you say? You will not ask how the money came, nothing. You will just take 45% and, 45% you take it and go. One jeweler, he deposited some 325 crore like that. So the government tried, rather than, see, it's a carrot and stick approach. Carrot approach is this. Carrot approach was this only. Please come, nobody came. Correct? Nobody came. Then, actually it was not a success because many people did not come, fearing that, it would be, though you will say that I will not ask you questions, but the moment you file, I will do Control S, because tomorrow I will be seeing how much you are filing. Correct? No? That's why people didn't go ahead. But those who went, they said no prosecution, nothing, bindas, no problem, no harassment, they went. This was what happened first. Second, what happened? On November 8th, 2016, Narendra Damodar Das Modi came before everybody and said, Mitro, 8 o'clock he came and he said, from 12 o'clock, all the notes, which notes, 1000 rupees, 500 rupees, gone, demonetization. So this was a pre-planned actually. This is number 1, this is number 2. You said carrot approach I used. I requested you to, give it. You didn't give it. Now it is November 8, 2016. Now no choice. All the money gone. Interesting statistic from November 8, 2016 to December 31st, 2016. Some 30,000 companies which were 1,30,000 companies which were dormant stage, which had not been doing any business, suddenly woke up and they had deposits of 30,000 crore. Narendra Modi and Amit Shah are asking, bro, how come? How come 30,000 crore? Where did the money come from? That is one part. So if you analyze the definition of dormant company, which again they will ask you in the exam, section 455, dormant company, though it is in section 455, they will ask you. Anyway, I will share the chart. I mean, here on the screen, you can take a picture of that, which I teach for CA final students. 1 second. So you can just take a picture of that particular chart. This is my CA final chart book. Yeah. Very simple. Section 455 says that you either have to be an inactive company. Means what? You are not carrying on any business or operations. Correct? And there is no significant accounting transaction from the last 2 financial years. This is there for your CA Inter also, buddies. Definition they may ask you. Definition. So inactive company means what? Which is not carrying on any business or operations. It has no significant accounting transaction from the last 2 years. Correct? Significant accounting transaction means what? Buying and selling of goods, those kind of transaction, not paying rent, not filing, all those things. Correct? So it has not filed annual return or financial statement for the last 2 financial years. So annual return has to be filed within 60 days of the AGM. Financial statements have to be filed within 30 days of the AGM. It is very much part of your syllabus, all these things. Annual return is section 92, which is part of your syllabus. Financial statement is section 129, financial statement. Filing the financial statement is 137, that is also part of your syllabus. So if you haven't filed for last 2 financial years, then it will be called as a dormant company. It will not automatically be converted to a dormant company, but you need to go there and apply. None of the companies applied. This 1,30,000 companies had not applied for dormant status, but it was, since they had not applied for dormant status, but when they checked the transactions, they should have applied. And dormant company, can you start a dormant company also? Yes. Because in India, there are brilliant people at age 17, 18, etc. They would want to do something called as a startup. But before that, they would want to finish their studies. Correct? So for instance, there was this person from IIT. So he came out of the room one day, almost around 10 years ago. He hired a taxi by calling a taxi company. He wanted to attend a party from IIT to some friend's place. There was no auto facility, so he ordered a taxi by calling. That time 10 years ago, they were just calling. The taxi fellow did not come. So he got pissed off and he came into the room. And his other friend and himself were studying, were learning Spanish as well. So the other friend came and said, hey, Ola Bhavesh. His name was Bhavesh Agarwal. They just came and told, hey, Ola, what's up? Ola means hello. This guy heard it and like, hey, why don't we do something? He checked online, which is the most famous, largest taxi company in the world, Uber. But he found out in Uber, how many taxis do they own? 0. So he understood that Uber doesn't own anything, but still it's number 1 company. Why don't I do it? That's why Ola Cab started. But he waited for his education to be completed. He was not a dropout. Now in this scenario, in India, it's such that when I create something, anybody else will copy or anybody else will get the same idea and execute. That's the beauty of the Indian brain. because we are young and we have brains, all of us, and we can come out with ideas. And it is not impractical or even, what do you say, it's not impractical to assume that you and I can come out with the same idea, correct? So that is the thing. So suddenly if I come to you, to the government and say, sir, this brand new idea of Ola cabs I've got, I have the intellectual property also with me, but I need a couple of years, correct? I need a couple of years to build this. So I need some time. Can you please start my company as a dormant company? Government will agree to it because you can now hold on to a intellectual property right. Intellectual property right. You can hold on to an intellectual property right. Plus, it should not have had any significant accounting transaction. Now the best part was, buddies, these 1,30,000 companies were there, no? They were dormant, means what? They actually did not have any significant accounting transaction, but they had not applied to the government to get the dormant status. And they had not filed annual accounts and annual returns. They had not filed for 3 years. Now, if you have not registered as a dormant company, but you are routing money through it, then the government will doubt it to be a sham company or merely a front which is used for money laundering. You have opened a company to do all this nonsense. They will think like that. And also, if you see section 248, if the ROC has reasonable cause to believe, and if you have not commenced the operation, or if there is no business operation, etc., and if you have not filed the annual accounts and annual returns, they will send a notice asking why I should not strike off your name from the company, from the register. So what happened was 1,30,000 companies suddenly came up, which was dormant stage, and deposit was 30,000 crore. Incredible deposit. 30,000 crore. So next step was in 2017, they sent show cause notices to all that 130 lakh companies and said, why should I not strike off your name? Because you have not filed anything, you have not bothered, you have not come to me and said that you want to convert to dormant, nothing. Suddenly you are depositing. Where, how come money came all of a sudden? Correct? So that is the thing. So when this happened, guys, government also decided that there are so many sham companies in India. So they sort of created a foundation, again in the Companies Amendment Act 2017, by speaking about something called layers of companies into clause 87, layers of subsidiaries, layers of investment companies under 186(1), and third one, beneficial owner and significant beneficial owner under 89 and 90. Sir, all these things are there for my syllabus, sir? Yes, sir. They said you are creating sham companies. I don't trust you. You are only creating companies, through that you are routing money laundering. All chartered accountants, lawyers, company secretaries, some crooked, some black sheep in the community, they are doing all these things. So they decided, many people, you know what happened? If you have watched this movie, Wolf of Wall Street, he sells those stocks of companies, correct? He sells those stock of companies where suddenly, he calls up and says, amazing company, and they'll show the company, it's a garage. So many people got swindled by this, even in India, whereby they thought the company was good, but the company was actually a public restroom. The register office of the company was a public toilet. Imagine. One more was a garage, like that. So what they are trying to do now was, they said, nothing doing. You just randomly gave some address. Now you do one thing, you give the geotag location of the company. Google geotag will be there, no? Give that first. Take a picture of the building, take a picture of your board, take a picture of your office, take a picture of the company secretary sitting in the office, take a picture of the managing director, send it to us. I know you can still Photoshop, that's okay, but at least I know that the board is there, and send me the location. I will do a surprise test sometime. And to declare all these things, I need a chartered accountant to certify that he has checked all these things. Chartered accountant, company secretary, lawyer during incorporation. If he has not done all these things, then the chartered accountant will be liable. That is the concept of active tagging. What do you mean by active? Active company tagging identity and verification. ACTIVE, active. Please prove that you are an active company. Please prove you are not a sham company. You know, in 2018, they disqualified 1,32,000 directors because they were all part of sham companies. That's what happened. So they said that on 15th June 2019, you need to file this. Every company incorporated on or before 31st December, after all this, 1 year after this demonetization. Everything is connected, guys. Everything is connected, right? All right. So active company tagging identities and verification, active. So every company incorporated on or before 31st December 2017 will have to file the form active. Active tagging when before 15 June 2019. If you don't do that, then I am going to disqualify all the directors. I am going to deactivate the DIN. I am going to put penalty. Got it? This was the active tagging thing. Now what has happened is amendment. This was all the story, backstory to come to the amendment. Now come to the amendment. Blindly reading the amendment is of no use. You need to know the history of the amendment. Blindly reading the amendment, what is the point? You need to know the history, how it came, what it was. Correct? Don't you think so? History you should know. This was the history. Now the thing is, they deactivated the DIN. So you have to file the DIR 12 and all those things. Now they are trying to tell, they have inserted one more rule, rule 25A, they have amended it. And now in a nutshell, if you see, ROC will not register form number DIR 12 with respect to change in the director of the company. Change in the director of the company if it is active non-compliant company. So if you have not filed the active thing and a new director is coming in, old director is going out and all those things, whenever a new director is coming in, the company has to file something called as DIR 12. Company has to file DIR 12. So this DIR 12, if they are not filing, even if they are filing, it will not be accepted if it is active non-compliant. Got it? That is a general rule. If you have not complied with this active, if they have not complied, Harika, I have already explained the difference between dormant and shell companies. You please rewind the lecture and watch it. I have already explained when it is dormant, when it is shell. Okay. But DIR 12 can be registered by the ROC. Correct? Now, what they are trying to tell is, if you are active non-compliant and one director comes in and an old director goes out, this DIR 12 I will not accept is what they said. But these are the exceptions. So they can give you a 2-mark question, 4-mark question, all that. Means what? But DIR 12 can be registered by ROC even if the above is not satisfied. They said it's okay. This is a relaxation given now. They said if I make it too stringent, it will be too demanding. I have to relax a little. So this is the relaxation given. What is the relaxation? First of all, cessation of any director. Means if the director dies or something, then I cannot help it. Correct? Active non-compliant need not be a shell company. Active non-compliant is a company who have not filed their geolocation. I may be a company who is actually a solid legal company who has an office, etc. but I have not complied with active, I have not filed my geotag location. That doesn't make it a shell company, but there will be penal provisions levied on it. So, but if a director dies, now if a new director is coming in and I am sending the DIR 12, ROC is telling you have not filed the active, I'll say, sir, very sorry, I will do it, sir. There are so many problems happening in the company. Please, the new director has come in, old director died, sir. Old director resigned, sir. Old director's office came to an end, sir. Company will be without a director, sir. All directors have resigned. Company will become without a director. So please help me. I will definitely file the form. So they say, okay, relaxation is given. Second, appointment of directors to receive minimum strength of directors due to disqualification of some directors. What do you mean by this? What is the minimum number? If you see minimum and maximum number, it depends. So first of all, I'll talk about public company, and then I'll talk about private company, and of course I'll talk about OPC. So as far as shareholders are concerned, as far as directors are concerned, shareholders, directors, shareholders and directors. Shareholders, what is the minimum number? What is the maximum number? Minimum, maximum, same here. Minimum and maximum. Tell me. For a public company, what would be the minimum number of shareholders? 7. Maximum will be unlimited. For a private company, what will be the minimum number of members? 2. Maximum will be 200. For a OPC, what is the minimum number of shareholders? 1. Maximum also should be 1. Simple as that. On the other hand, for a public company, minimum number of directors would be 3. Maximum would be 15. Maximum would be 15. Private company, minimum will be 2, maximum will be 15. Similarly, OPC also, minimum will be 1, maximum can be 15. Director, maximum can be 15. The shareholder should only be 1. Shareholder should only be 1, but director can be maximum 15. If I want to go more than 15 in any of these cases, I have to pass a special resolution. Yesterday we have seen what is special resolution, so that is the same. Now what I am trying to tell is, assume I am a private company with around 3 directors. Now 2 directors have resigned. The company only has 1 director. If the company does not appoint 1 more director immediately, minimum number 2 will not be there. Minimum number will not be there. How is it possible in case of OPC? How is it possible means, what do I say, Karthik? 1 person company is 1 person company with 1 shareholder. It has got nothing to do with director, right? So you can have 15 number of directors. For that you can read 149, you will get your answer. Anyway, so if you see this, what I was saying, directors. There are 3 directors in a private company. Assume 2 directors resigned. Now I have only 1 director, which means it is below the statutory minimum. Statutory minimum is 2, but unfortunately I have 1. If now I appoint 1 more director to at least make it 2, then I am sending that fellow's form to the ROC. ROC will see, they have to accept it. Before accepting, they'll say, have you filed your active form or not? The company secretary says, no sir. Earlier what they used to do, then this DIR 12 also rejected. Now some relaxation they have given. They have told, okay, I understand your problem. Everybody is leaving and going. Now at least you have brought me the minimum number. No problem. You have not filed active. I have my eyes on you. Please file active quickly, but I will take this. No problem. Are you getting my point? That is the relaxation. That is the relaxation. Appointment of directors to receive minimum strength of directors due to disqualification of some directors. Due to disqualification of some directors. Got it? So if some directors get disqualified, there is a section of disqualification under 164. So in this, see, you guys need to know section 164. Why? Though 164 is not there in your syllabus, 186 is not there in your syllabus, 185 is not there in your syllabus, though it's not there, still you need to know because they are all linked in auditing. These two come under CARO, clause 3, 4 and 13. So it will anyway be, CARO, it will be applicable. 164 as far as disqualification is concerned. This, if you see, it will again come in auditing as part as the auditor's reporting requirement. Auditor's reporting requirement. Where will it come? Let me quickly show you. Auditor's reporting requirement. You need to know all these disqualifications, etc. You cannot just, let go of it, because if you see my reporting requirement, every company after 31st December 2017 has to file active. Every company. (143)(1). You see there? 143(3). G. 143 is part of your syllabus, yes or no? Full you have audit reporting. 143(3)(G you see. Whether any director is disqualified from being appointed as director under subsection 2 of 164. They have asked this also 4 marks question. They have linked it to 164 and asked you in the exam, in auditing. It not just in auditing, it can also come in law also, because chapter 9 and chapter 10 are very much applicable for you, right? So what I am trying to tell is 164(2), you need to know what it is, we will see later. If you are disqualified under 164, then automatically as an auditor you need to what? Disclose. You need to report this particular point, correct? You need to report this particular point. Are you getting it, guys? Whether any director is disqualified from being appointed as a director under subsection 2 of section 164. Now coming back to this amendment. What is the relaxation? Cessation of any director. Second, appointment of director to receive minimum strength of directors due to disqualification of some directors. Out of 3 directors, 2 directors, let's say, are disqualified because of 164. 1 director is remaining. So it's urgent now, I need to appoint 1 more director. I have gone to the ROC. ROC is telling, no, you are an active non-compliant company. I'll say, sir, please, I beg you. That is the amendment. Got it? Third one, appointment of any director in such company where DINs of all the directors have been deactivated. Same. They have been disqualified, or they have not filed the returns, or they have not done something. MCA has completely deactivated their DINs. Now, don't you think so? The company needs a director. So I'll appoint new directors. Then that new director's forms I'll go and give it to the MCA. MCA again tells, no, there you are disqualified, you have not filed, here also I'll disqualify. I'll say, sir, please let the company run. Objective of MCA is never to kill the company. Objective of company should go on, but you should follow all the rules and regulations properly. Okay. Then lastly, appointment of director as per the order of the court, NCLT under IBC. So insolvency and bankruptcy code. When you come to CA final, you will understand. Insolvency and Bankruptcy Code, IBC, overrides Companies Act. So under IBC, if you are appointing any director, it overrides Companies Act. And even if you are an active non-compliant company, you can go ahead with it. Did you understand this 4? They can ask this in the exam, guys, because obviously they have never asked it before and it's a brand new amendment. Are you getting it, guys? Generally, the MCA will not allow, but in these cases, they are allowing 4 cases. Cessation of any director, appointment of director to receive minimum strength of directors due to disqualification. Third one, appointment of any director in such a company where DINs of all or some of the directors have been deactivated. And lastly, appointment of a director who has been appointed by the court or NCLT under IBC. Because as I told you, IBC overrides Companies Act. How, why and all you need not know. When you come to CA final anyway, you will have. When you come to CA final, you will have it anyway. So you need not check all those things. Got it? That is regarding IPC. Got it? That is regarding the second amendment. Now coming to the third amendment. Shifting of registered office. Shifting of registered office. Here it's very simple thing. When you are shifting the registered office, correct? One ROC to another ROC. Okay, there are various types of shifting the offices. So this all comes in with section. This comes under the alteration clause of MOA. Tell me one thing, guys. If I want to alter the MOA, this section, section 15. If I want to alter the MOA, section 15 talks about it and section 13 also talks about it. If I want to alter the MOA, what resolution is needed? You need a special resolution to alter. This is given in section 13. So if I want to talk about alteration of MOA, see, if you see with the amendment, I'm linking the chapter. With the amendment, I'm linking the chapter. Now I'm talking about alteration of MOA. As per section 13, it says special resolution is required. But I am saying there are various clauses. This is like a general statement. But there are various clauses. You have the name clause, we just discussed. You have the situation clause. You have the objects clause. You have the liability clause. You have the capital clause. And you have the association clause. When two people in a private company or 7 people in a public company come together, list out the terms and conditions and sign on the MOA, they are called as subscribers to the memorandum. Once you have already signed, you will get something called as the certificate of incorporation. Certificate of incorporation is the conclusive evidence that the company is already there. Once you have already created something, can you go and tell later that I never created it? Isn't it absurd? Once you already created something, can I say I have to alter it? No. Can the association clause be altered? No, dear friends. That's what I'm telling. This line is a general statement, that's all. This section 13 line is a very, very general statement. For everything you can't take special resolution. Correct? For everything you cannot take special resolution. Because here in this case, association clause can never be altered. Sir, but section 13 says, yes, section 13 generally is telling if it can be altered, then okay, special resolution. Association, when 7 people have already come together and COI is already got, tomorrow can you say, no, I never did it? No. Those who are subscribers, you cannot change the fact, correct? So that is regarding association clause. Association clause can never be altered. Those who subscribe to the memorandum can never change. Now, coming back to this, name clause. Now tell me, in name, no, actually, one comes under the normal name clause. If I want to voluntarily change my name. One more is what, guys? I have used somebody else's name. I have breached the trademark of somebody else, and then it is going on. I have breached somebody else's trademark. I have breached somebody else's, intellectual property. Can the other person come and tell me that, boss, you have used my name. My company name is Infosys. You have named it Infosys. How come? How dare you? I will lodge a complaint directly with the ROC telling, why the hell did you even allow that company to go by the name of Infosys? Why did you go? Why did you allow? I have this trademark which is valid for life. I want him to change his name immediately. So one is voluntary, one is called compulsory. Compulsory is given under section 16. Now tell me, when the government is ordering you to change, use your common sense. When the government is ordering you to change, is special resolution necessary or just an administrative ordinary resolution is needed? You only use your common sense. Section 13 says special resolution, but use your common sense. When compulsorily government is telling, hey, change it, you need a special resolution or just administrative ordinary resolution? Ordinary resolution is enough. So under section 16, ordinary. I told you yesterday there are certain sections where they have used the word ordinary. One I told you 169 removal of director. One more is this ordinary resolution. So if it is a registered proprietor and all that, one of you have already given the answer. 3 years, correct? WWE forever. What is your name, da? What a name to keep. Correct? So if you see trademark, if it is there for 3 years, within 3 years of coming to know that you are breached, I have to apply to the to my MCA and tell this company is using my trademark. So please ask them to remove. So they can remove by adopting what resolution? Ordinary resolution. Okay, Aman. WWE forever is Aman. Okay, so after adopting what? An ordinary resolution for this purpose. Yesterday I told you there are only 2-3 places in the entire Companies Act where they have actually used the word ordinary. One is 16, this one, and one more that I showed you was 169 where they have actually given a word ordinary resolution. Got it? So now buddies, if you see section 13 generally told special resolution, but here I am writing ordinary here, correct? Which voluntary nothing is given. So voluntary ke liye we have special resolution. Situation, objects clause. Can I change the objects? Yes, special resolution. Liability, if it's a company limited by guarantee, limited by share capital, limited by guarantee and capital, you can't keep changing that very, very easily. You need to change the structure. So generally it cannot be touched. Capital clause, now tell me. Situation, I'll come to it. Situation means what? Place. Situation means place. Will the names of subscribers remain the same? Yes, subscribers may or may not be shareholders later, but their names will always remain the same. For example, in Infosys, Narayan Murthy is no longer there. Gopal Krishnan is no longer there. They have all left now. Narayan Murthy is the chairman emeritus, but is no longer a part of Infosys. Correct, because he is not part of Infosys in any way. He is only the chairman emeritus, barring that nothing. So when the members may change, whatever it is, will the subscribers names remain the same? Yes. So if you just see, for instance, if I open Infosys ka MOA and if you see the names of the subscribers, it still remains the same. See, Narayan Murthy, Srinivas Raghavan, S. Gopal Krishnan, Nandan Nilekani, none of them are there. Nobody is there. But still, will the name of the subscribers change or not? It will never change. Got it? So, shifting of registered office. Now, okay, I will come back to that now. Objects clause, fine. Now guys, capital clause. Capital clause is given under section 61. So even if you see here in this section 13, save as provided in section 61. Save as means except. Except section 61, other cases special resolution. That's how you need to read. Except section 61, other cases special resolution. If I go to 61, there is no type of resolution given, which means if I want to change the capital clause, important for the exam, I mean generally interpretation, if I want to change the capital clause under section 61, what resolution is needed? Ordinary resolution. What resolution is needed? Ordinary resolution. Okay. So if you see, ordinary resolution is needed here. Here what resolution is needed? Special resolution. Here what resolution is needed? Special resolution. Here what resolution is needed? Ordinary. Now tell me, situation clause. In the particular situation clause of the MOA, only the state will be given. So if you are shifting from one state to the other state, only then MOA will change. Did you agree? Yes. Only then MOA will change. So under section 13, that time you need to pass a special resolution. You need to pass a special resolution when I am changing the situation. Situation means one state to the other state. When I am changing from one state to the other state, what clause is needed? Section 13, special resolution has to be passed. And I am doing from one state to the other state. But in the situation clause, there can be various, permutations and combination. It can be, for example, one area in Bangalore to the other area in Bangalore. If you see, using the amendment, I am revising the chapter. Using the amendment, I am revising the chapter. That's how you need to interconnect and study. Simply chapter wise like a fool if I do, boring it is. It should not be studied like that. If you study like this, you will know, okay, this is the amendment, okay, that is a chapter. Got it? One area in Bangalore to the other area in Bangalore. Am I touching the MOA? No. Do I need any sort of special resolution and all? No. Simple board resolution is enough. So the board only can decide, today I am in Malleshwaram, tomorrow let me go to Jayanagar. Those are two areas in Bangalore. Okay. So this part, no, it is there in that same material. Hope it's given. If it's not given, it's okay. Just discuss. Okay, here only amendments are given. It's fine. No problem. Don't worry. These are only amendments. See, all amendments are covered. We are going to check this. Don't worry. Anyway, I will show it to you in this, my main notes. It's okay. So that we will understand that particular part. You can take up a picture if you want to. We need to discuss the entrenchment also. Cool. It's okay. I'll do one thing. Rather than sitting and searching, I'll write it here only. See, one area in Bangalore to other area in Bangalore. No. MOA is not changing. Board resolution is okay. Second, what happens? One city in Karnataka to the other city in Karnataka. So, from Bangalore to Mysore. Again, is MOA change needed? No. So, in this case, I will pass a board resolution, and also I need to take, the approval of the ROC. Because I'm not changing the ROC, but I'm just with the same ROC approval I need to take. Correct? On the other hand, if I'm changing from one city to another city, see, in Karnataka, ROC is the same. Full Karnataka only has one ROC. Andhra Pradesh, one ROC. Telangana, one ROC. But in Tamil Nadu, there are two ROCs. Because Tamil Nadu has a major port in Chennai and one business district which is Coimbatore. So it has lot of companies are there in Coimbatore, lot of companies are there in Chennai. So to manage it properly, there are two ROCs. One is in Coimbatore, one is in Chennai. So now tell me guys, if I am shifting from Chennai to Coimbatore, same state, will MOA change? Definitely not. But guys, I am shifting from one ROC to the other ROC jurisdiction. Correct? One ROC to another ROC. Yes, then Mumbai and Pune, correct. Maharashtra also has two, Mumbai and Pune. Mumbai because it's again port city. Pune is your industrial district, that's why, industrial town, city. So from one city to another city, if I do with a different jurisdiction of ROC, again I have to take a special resolution. and I have to take the permission of the ROC's boss. ROC's boss is the regional director, because I have ROC Chennai also, ROC Coimbatore also. So I have to go to his boss, Southern Regional Director, South India Regional Director. I have to go to him and say, sir, I want to shift. They'll say, okay. Praveen Kumar is asking, am I from Tamil Nadu? No, man, I am from Karnataka. But I'll be visiting, I have visited Tamil Nadu so many times. And next year, now this year Corona, next year in 2021, I will be coming to Chennai to do face-to-face classes. I'll be doing CA Inter as well as CA Final, and couple of batches of Foundation also, because I want to come and interact with the people of Chennai. And I may be going to Coimbatore also, ROC to ROC. So I may be going to Coimbatore and Chennai. But I visited almost so many places in Tamil Nadu. It's a beautiful state indeed. But when it comes to cricket, I'm a hardcore RCB fan. Anyway, we'll lose. CSK versus RCB, anyway, we'll lose. I've already accepted it, but still I would definitely support our team, though we'll lose. All right. Yes. So if you see that Chennai to Coimbatore, understood, that is one ROC to the other ROC. So if you see fourth one, correct? The next one is what? Is yeah, this is one state to other state. Now if I shift from Bangalore to Chennai, only then MOA will come, change. If I shift from Bangalore to Chennai, only then MOA change will come. Now again a special resolution has to be passed under section 13. Did you get it? This is how it is there. This is how we need to think of it. From Bangalore to Chennai, if you are going, same way. MOA, special resolution, section 13. Got it? Now the question is, this only, let's concentrate on this now. Now that we have understood the foundation, now concentrate on this. If I am shifting from Chennai to Coimbatore, ROC is changing. One ROC has to talk to another ROC. I have to take the RD approval. CG here is regional director only. Regional director is an employee of a central government. So rather than taking CG approval, I can take RD approval, because central government has already delegated the power to RD. I have to take the RD's approval. How will I take? What will I do? How many days? That is the amendment. Come to the amendment. In case of change of registered office from one ROC to another within the same state, this is Chennai to Coimbatore, Mumbai to Pune. Regional director will provide his assent or dissent within 15 days of application. And later on, his assent must be filed with ROC in the next 30 days in form number INC 28. So, since you are shifting from ROC 1 to ROC 2, you need to take the approval of the regional director. You need to make an application to the regional director. Earlier it was 30 days. Now they say, do not waste time. Give your approval within 15 days only. And then file your assent with the ROC within the next 30 days. In INC 28. Did you get the amendment, guys? Get the amendment? That's the thing. And if you see the procedure from shift of one place to the other place, let me see. Let me put up this chart. This is Chennai to Coimbatore. The procedure goes like this. Board resolution has to be passed, then board resolution and a special resolution, not under section 13, but under a different section 12 you need to pass. Regional director, you have to take the approval. Now regional director will give the confirmation. It was 30 days before, now it has become 15 days. As you can see, along with the amendment, I am doing the procedure also. That's how we are going to revise. Maharashtra and Pune also 2 ROCS. Got it? So the regional director will confirm within 15 days. And I have to file form number INC 23 and a declaration by 2 directors that there is no default in dues till now. There is no objection certificate I have taken from the creditors, and I will not seek any change of jurisdiction, because once I go to this thing from Chennai to Coimbatore, again I cannot tell from Coimbatore I will come to Chennai like that. I should make a declaration and I have to take a no objection certificate from my creditors. Correct? Yes. So if you see, that's the thing. Now coming back to the regional director. Regional director will give the confirmation within how many days for November examination and onwards, November 20, May 21, like that. Within 15 days, he'll give a confirmation, and that confirmation should be filed with the ROC. This also has changed. Now 30 days. It has become half now. It was 30-60, it has become 15-30. 30-60 has become 15-30. This is the amendment. Got it? That's the thing. Yeah. Notes 30-60 was there. No, it has been amended to 15 and 30. It has been amended to 15 and 30. We'll come to it. Got it, guys? This is which one? Amendment number 3, shifting of registered office. Very simple. Think about those things, amendment and the interconnected points, and then study. Becomes easy. This is very simple, guys. Yeah, ease of filing documents, ease of business, they have maintained this. Yeah, amendment number 4, change of application form to form a company with a charitable object. Section 8 is such a company which is used for charitable purposes. INC 23 is the application form. INC 28 is the final form that you have to file with the ROC after everything is done. The order that the regional director gives, no, that has to be filed in INC 28. INC 23 should be filed at the time of application. You will apply in INC 23, and after application, when you get the approval, you will file it in INC 28. So here, guys, very simple. See, basic rule of incorporation, or rather the basic procedure of incorporation is slightly different. Procedure of incorporation is slightly different. This was generally the procedure of incorporation. Reservation of name will happen first. Reservation of name used to happen in INC 1. Then you used to make an application form. Application form used to happen in INC 7. Then you will draft and sign the MOA, AOA, e-filing, e-stamping and all those things. All the compliance declaration, everything, documentation, additional documentation, even if there's an additional documentation used to happen in INC 10. Consent of the persons nominated as director, you will again file DIR 2 and DIR 12. Remember DIR 12 we just discussed in the active form. Then you will do a statutory declaration of compliance. This happens in INC 8, used to happen in INC 8. You will pay the fine, fee, etc. COI, Certificate of Incorporation, should have been filed in INC 11. And registered office declaration you will do in INC 22. This is the procedure of incorporation. This, dear friends, is no longer followed practically because they now have a very, very simplified procedure. Simplified procedure of incorporation of company electronically. That's the full form of SPICE. Simplified procedure of incorporation of company electronically, SPICE. Because of SPICE now, things have become very easy. In SPICE, there is absolutely no tension. Correct? Everything is filed under INC 32. Everything, all the forms that I told you, filed under INC 32. And the MOA and AOA are filed under INC 33 and 34. Only 3 forms. INC 32, E-form MOA 33, E-form AOA 34. There ends the matter. Now the SPICE was only for normal private companies and normal public companies. They wanted to extend SPICE to also Section 8 companies. Correct? Section 8 companies. That is all there is. They have to increase this to Section 8 companies also. I mean, they have to extend it, sorry. That is the amendment now. Check it out. Application to start Section 8 earlier was in INC 12. Now they have shifted it to INC 32. Same SPICE. Also, while filing the documents now, MOA will be submitted in same INC 33 and 34. It will be done in INC 33 and 34. Are we clear? So this is the scene, 33 and 34. Very, very simple. 33 and 34. That is the amendment, guys. Which one? 33 and 34. So whatever is there for the normal companies has been shifted to whom? SPICE. SPICE has been shifted to whom? Section 8 companies also. Section 8 companies. Now as far as amendment number 5, it's very simple. What they have done is, this is, we know that all listed companies should have have their shares in dematerialized format. Means what? No physical shares are there anymore. This has also been extended to unlisted companies now. Certain unlisted companies also should go for demat. Unlisted public companies, that is. Only private companies are allowed to have physical share certificates and all those things. This also will become demat very soon. So because of which has all the new unlisted companies which are now governed by the new provisions of issuing demat, they have to file a form. So check this out. Return they have to file, half yearly return. Check it out. Half yearly return with the ROC has to be filed in PAS 6 within 60 days from the completion of half year. And it has to be attested by a CA or a CS in practice. So half yearly return with the ROC in PAS 6 within 60 days from completion of half year. Correct? And it shall be attested by whom? CA and CS. If there is any change in the issued capital, etc., or shares, etc., in the demat form, then you have to intimate to the depository. You have to intimate to the depository. So if you see the member definition is the subscriber to memorandum. I told you, Nandan Nilekani, Gopal Krishnan, all these fellows are called members. Second, in an initial public offer, if the shares are allotted in your name and your name is mentioned in the register of members, then only you are called as a member. But in a stock exchange, morning I own the shares. It is now passes through almost 10-15 people and by evening it goes to you. Whose name is entered in the register? My name or your name? It doesn't work like that. So there is somebody called as a depository. Two depositories are there in India, NSDL and CDSL. National Securities Depositories Limited, Central Depository Securities Limited. So these have links to various banks. It may be SBI, maybe ICICI, HDFC, Axis Bank, whatever, many banks. In each bank I can open a demat account. So essentially, if I am transferring from one demat account to some random demat account here, ultimately it is being controlled by the depository. So depository's name will be entered in the register of members, but the beneficial ownership, dividend, etc. will come to each of these people. And these banks are called as depository participants. Depository participants. Right? So now what they are trying to tell is, since now everything should be for unlisted company, it should be in a demat form. Any change in the shareholding from one person to other person, if I am selling, etc., I have to intimate NSDL and CDSL. I have to intimate NSDL and CDSL. Got it? That's the amendment. Any change in the issued capital and shares in demat form, intimate to depository. Intimate to depository. Then matters to be stated in prospectus. Earlier you had to register the prospectus and all those things. Now all the prospectus items are governed by SEBI only. There has been an amendment. Yes, Sumedha, beneficial owners will be changing, obviously. The names will be only the name of the depository, depository, that is your NSDL, CDSL, but the beneficial owner or holder will keep changing during the day. That is not in the records of the company, but it will be the records of the depository. So if you see the member definition, you will come to know what I am trying to tell. Okay. So now, as I told you, the SEBI, earlier there was the contents of the prospectus. Everything has been shifted to SEBI. Since it is shifted to SEBI, I need not register anything, I should only file. So registration under MCA has now been converted to filing, because registration, etc. will now be under SEBI, replaced with filing. And as I told you, the public offer of securities should always be in the demat form, which anyway we know it was all for listed companies. Now they say this, in such classes of companies of unlisted. Unlisted can be two things. Unlisted can be unlisted public also. Private company are automatically unlisted. What is an unlisted public company? It means it's a public company whose shares are not listed on the stock exchange. Then who are buying those shares? Large institutional investors, big institutions, investment bankers, venture capitalists, they are actually investing in that company. It is not public, which means it is given to the public as such, but it is unlisted in nature. So amendment number 7 talks about that. What type of companies we still don't know. What type of companies we still do not know that can issue demat is still not known, but they will eventually tell us. But what is the change is that very simple, dematerialization of securities by prescribed unlisted company also possible. What is prescribed? Not notified yet. Not notified yet. Again, amendment number 8, if there is any civil liability for misstatement, earlier I had to do it under Companies Act. Now I told you the entire concept has been shifted to SEBI, because of which it says filing a copy of prospectus should be enough. Filing a copy, the prospectus should be enough. Alright guys, cool. So the doctor has advised me not to take 2 hours. If need be, we will extend the classes to 22nd, 23rd and all that. But he says, please do not risk your lungs, because if there is again more exertion, then definitely there can be a relapse. In Bangalore recently, there was a COVID reinfection patient. So he said, lungs are still weak, anything can attack. Forget corona, any other virus also can attack. So he said, please slowly do it, 1.5 hours, 1 hour, 40 minutes you do. Don't go bang 2 hours, at least for the next 2-3 days. So ultimately guys, I need to follow the doctor's advice. In fact, he told me do not teach 1 hour also till September 30th. From October you can teach, he had told, but I had committed to you, right? And once I give a commitment, I will never go back on it. So whatever it is, I had told you that I'll come and revise, whether I'll put videos or whether I'll come and revise, whatever it is, I had promised you. So it is not right on my part to fall back on my promise. That's the reason why I had told him that, sir, at least let me do 1 hour 30, 1 hour 40, 45 minutes, at least till 7:40, 7:45, it's okay. He said, okay, at least that I can allow you, though it is not advisable. That's okay. I have already spoken to my doctor. So that's why guys, I need to take it easy for the next couple of weeks. I should not, go all out and record 5 hours, 6 hours and all those things. So that's why tomorrow we'll continue. If need be, if we cannot make up for it, we can still go for 2-3 days later. That is still okay, rather than exerting and then falling sick again. I hope you understand. So on that note, anyway, this much is enough. We have done solidly today. We have done a lot of amendments. This is the way to study amendments, not amendment number 1, this has come. Old was this, new was this. Like that, if you study, you will never pass. Even if you pass, tomorrow if somebody asks you the logic, you will be like, oh, what to do? Correct? Yes. So you can rewind today's class now itself, no problem. Okay? Yes. So we can resume tomorrow, same time, 6 p.m. Shall we? See you tomorrow, 6 p.m. You can use the next link, day 4 ka link, like that each day ka link you use. If someday I cannot take, means if the doctor tells you take rest and all, that relevant portion ka video I will upload. Do not worry. Your classes will not be stopped. That is my promise. That relevant video, I have recorded recently only, just before I fell sick. That relevant video, if it is relevant, I will upload and I'll share you a separate link. So don't click on that particular link. If someday I cannot take. But 99% I will come every day. But if the doctor says, boss, one day you chill and all, if he tells so, because it all depends on what the doctor says, then I will play that day's video, don't worry. At any cost, your classes will not be stopped, your classes will not be discontinued. I am not that kind of a person who will make a commitment and fall back on it next time. Alright, on that note, thank you guys. Tomorrow we'll be continuing with the amendments, okay? Bye. See you tomorrow. Take care.